You ready? Good morning. Happy Friday. Michael Love, come up.
It's two, Michael Love and a Michael Love Jr.
Oh, really?
Junior and third.
Okay, Michael Love Jr. and Senior, come on up. Who's Junior? And you are the third. Gentlemen, both of you are charged with evading arrest or detention. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay.
On February 20th, 2025, officer dispatched the First Baptist Church. A caller stated that a white pickup truck parked behind the Baptist Church and she...
All right, quick setup before we jump in. Probable cause is not about guilt. It's about whether the state has done the bare minimum to justify dragging someone deeper into the system. And today, you're about to see what happens when that minimum is not met.
Exit the doors on the west side of the building. The defendants then turn and look at the officers and then run in the opposite direction for approximately 30 yards to C Street, run an additional 20 yards to First Street, and then turn and run an additional 30 to 40 yards. Due to the circumstances of the incidents indicating this was possible burglary in progress, with fleeing suspects who could have been armed, the officers drew their duty pistol and gave defendant Love Jr. several commands to get on the ground and allow him time to reply. He disregarded the command, so the officer took defendant Love Jr. to the ground. Defendant Love III ran around the building and then subsequently followed commands to lay on the ground. They were both detained. Defendant Love Jr. stated that they panicked, so they ran. The officer stated, "You looked right at me and knew I was a cop, but you still ran," to which the defendant stated, "I know, bro, it wasn't the right thing to do, sir."
Your Honor.
They look at the cop and they run.
Yes, sir.
Cops never tell them to stop. And what are they doing wrong? I guess, what is this, Minority Report? You know what I mean?
I don't know anything additional to say.
Guys, be careful. You know what I mean? How old are you, sir?
18.
You gotta be careful, man. When you start racking up convictions, life doesn't get easier, man. It gets so much more difficult. And the more convictions you rack up, you're only 18, man. Life doesn't get easier. You get bigger, fatter, you lose hair. It doesn't get easier. And the more convictions you get, the worse you make life. Life is all about money. And if you have money, then life is great. And you only get it with one thing. This or this. Hard work or knowledge. Going around picking up cases, that's not the right way. Don't pollute. Do you understand? Sir. I'm going to find no problem.
Notice what's missing here. No clear command to stop. Running looks bad, sure, but legally, looks don't convict people. The law cares about what was said, not what officers assumed the defendants understood.
255-9578. He's already got conditions from Judge Simons. Where do you go?
Judge Simons.
Yeah.
Okay.
Judge D. Simons. And so it's my understanding there's no alcohol. He's got a device also already, I think, or at least we can double check.
All right, sir. You are Mr. Kubler.
Kubler, yes, sir.
Kubler. Mr. Kubler, you're charged with driving while intoxicated, second offense. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent.
This is where judges quietly save people from ruining their own lives. Judge Fleer isn't endorsing bad decisions. He's enforcing the statute exactly as written. That distinction matters more than most people realize.
On April 25, an officer was dispatched to an unknown accident, and noticed a vehicle, a pickup truck, illegally parked in the front yard of the residence. There were fresh tires, skid marks, a broken wheel, and axle visibly appeared to be damaged from the Ram truck to a legally parked red Jeep Compass. The law enforcement officer made contact with the complainant, and then it said that the damage to the Jeep was approximately $5,000. The defendant admitted to driving the truck. Was later identified. The officer also made contact with the wheel witness, who said that he witnessed the defendant in the white truck in the driver's seat behind the wheel and observed an exit vehicle from the driver's side door. Upon exiting the vehicle, the witness observed he was not stumbling, and then the witness observed slurred speech and strong odor of alcohol that was emitting from the defendant's breath and personally. The defendant also admitted that he was trying to clear the scene and go home, but his vehicle was stolen. The officer made contact with the defendant, who was detained, and noticed a strong odor of alcoholic beverage. The officer then conducted a standardized field sobriety test, where he witnessed. Sorry, Your Honor, the DIMS leaves off and does not show the standardized field sobriety test results. The officer asked the defendant his intoxication level. The defendant said he was at a 6 out of 10. The defendant said he does not believe it was safe to operate his motor vehicle at this level of intoxication, but had an 11-year-old passenger.
He did not.
I'm sorry, he did not. He did not. I apologize. Just a moment to see if I can.
Judge, I'm going to tell you that's kind of where the DWI investigation stops. The first response that I have is that no field sobriety tests were performed. It also, the credibility of the wheel witness was never discussed in the DIMS, whether the officer found them credible or reliable, etc. So I really can't make a lot of sense out of.
It's like the DIMS you're reading these like going through a drive-through, man. I mean, really, who's writing the reports?
Yes, Your Honor.
Over and over and over. I mean, really,
Trying to see if I can find anything else.
case after case, we're just,
So Judge, things don't say it, don't say or what is the results of those van revealed sobriety tests, and we do not have an officer.
how on earth am I supposed to find probable cause when Mickey Mouse is writing these reports?
I don't say, I don't know why it's not in the DIMS. Obviously, we didn't write it in here. We represent what is written in there, and so I understand your frustration. I'm highly frustrated.
Mr. Kubler, I'm going to find no probable cause in your case. Don't kill anyone. You know, every single day on the news, how many people die in our county because of a DWI? How many? Every single day. We lead the nation in alcohol-related collisions and fatalities because of boneheaded moves that are made day in, day out. Now, this is not to say that they may not indict this case at a later time, but be whatever, just don't kill someone, please. Take a seat, please, sir.
Thank you, Judge.
Thanks.
Judge Fleischer enters a finding of no probable cause based on deficiencies of allegations in the so-called DIMS report. A DIMS, D-I-M-S, short for the District Attorney Intake Management System, is the report that's generated when a police officer electronically submits criminal charges for a warrantless arrest to the Harris County District Attorney's Office. According to the DIMS manual, the report includes a
And Sion, anything you say can or will be used against you, sir.
Yes, sir.
On March 28, 2025, an officer was in the process of serving a capital murder warrant on a suspect in Harris County, Texas. While conducting a felony stop, the defendant, who was identified by his Texas ID card, pulled up on the officer's perimeter, got out of their motor vehicle, and began walking to the residence where the murder suspect was. The officer supervisor ordered the defendant to stop and stay right there. The defendant refused and continued to ignore officers while walking towards the residence. The officer supervisor ordered the defendant to step back multiple times and then grabbed the defendant and took him to the ground.
Him?
Yes, Your Honor.
Was he the capital murder suspect?
No, Your Honor.
I live there.
Stop.
Oh, sorry.
I believe that they were in the process of serving a warrant on someone else at the residence, and that's when they came in contact with the defendant.
Okay.
To stop. He refused to stop going towards the residence. Your Honor.
Did it serve the warrant? What ended up happening?
Looks like after refusing commands, there was a brief struggle where he was detained.
Was the murder suspect there?
I'm not sure, Your Honor. It does not say. I have no further facts that show if the warrant was, service was complete on the warrant or not, Your Honor, or completed at the time. I just believe they were in the process and believed him to be at the residence. And that's been this specifically.
Read it again, if you don't mind.
Yes, Your Honor. On March 28, 2025, the law enforcement officer and squad 5 of the Houston Police Department's gang division served a capital murder warrant for a suspect observed inside a truck at a nearby residence. While conducting a felony stop, the defendant, who is identified by his Texas ID card, pulled up on the perimeter, got out of the vehicle, walked to the sidewalk, and began walking to the residence where the murder suspect was. The supervisor then ordered the defendant to stop and to stay right there. The defendant refused and continued ignoring officers and walking towards the residence. The supervisor ordered him to step back multiple times when the defendant was.
When a judge starts talking about Mickey Mouse reports, that's courtroom code for this case is collapsing. If the paperwork doesn't establish probable cause, the entire arrest becomes legally radioactive.
Yes, Your Honor. That's what. So I was originally reading the summary. I'm going straight from the DEMS now, Your Honor. It looks like the suspect was observed inside a truck at a nearby residence.
So the suspect is not even in the residence. No.
Then they later state that the defendant here was walking towards the residence where the murder suspect was. I'm not sure, Your Honor. I don't think
I find no probable cause in your case. Just be careful, man. When you get into a pissing match with
I understand.
who's going to win,
They are. I understand.
no.
Yes, sir.
Hand,
All right. Sit down.
please.
Judge Fleischer determines that there is no probable cause to support the charge of interference with public duties. Under Section 38.15 of the Texas Penal Code, an individual commits the offense of interference with public duties by interrupting, disrupting, impeding, or interfering with a peace officer performing a lawful duty. While failing to comply with a law enforcement officer's instruction pertaining to physical conduct can constitute a violation of this statute under some circumstances, the command must be lawful, and the refusal to comply with the command must actually interfere with the police officer's performance of their duties. Here, the officers were focused on a suspect outside the residence, and Mr. Serna, who was not the target of the warrant, did not threaten, obstruct, or physically interfere with their movements. Although the officers instructed him to stay outside, the evidence did not suggest that his attempt to enter his own home created a safety risk or meaningfully disrupted the arrest operation. Without evidence that his behavior actually impeded the officer's duties, Judge Fleischer concluded that his conduct did not satisfy the statutory requirements for interference. Therefore, the state dismissed the charge against him the same day that Judge Fleischer found no probable cause. Our final hearing of this episode took place on April 25th, 2025, after Joseph Ramirez was charged with DWI on April 18th.
The council's approaching for page 15.
Okay.
Ramirez, Joseph.
Hi, Frank. How are you? You ready? Come on. All right. Good morning, Mr. Ramirez. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Your Honor. On April 17th, 2025, in Harris County, Texas, an officer observed a pickup truck change lanes without using a turn signal. The officer observed the vehicle change lanes twice prior to initiating the traffic stop. The officer approached and observed the defendant to be the driver and sole occupant of the vehicle. The officer noted a strong odor of alcoholic beverage emitting from the defendant. The defendant was ID'd by his Texas driver's license. The defendant stated that he did not know how to provide proof of financial responsibility. As the defendant responded to the officer's questions, the officer noted an odor of alcoholic beverage emitting from the defendant's breath. Standard field sobriety tests were conducted. A 6 out of 6 was reported on the HGN, and the defendant stated that he could not perform the walk and turn or the one-legged stand. The DIC was read, and the defendant refused to provide breath or blood voluntarily. A blood warrant was obtained and the defendant's blood was drawn.
Yeah, may I respond?
Please.
Okay, first of all, Judge, it's not on there for some reason, but the reason he told.
This is a critical reminder. Not every police command is automatically lawful, and ignoring a command only becomes a crime if it actually interferes with police work. Here, the state just couldn't bridge that gap.
As well, all you have is an odor of alcohol.
And
There's no accident. It's just a turn. All we have is an odor of alcohol. Is there anything else? Odor alone is insufficient.
No, Judge, he was coming from a tattoo shop, and the police officer asked him, "Is he alcohol because of the tattoo?"
Is he what?
He just had a tattoo put on. That's he was going. So that's the odor of alcohol.
Come on, man.
That's what. No, that's. I'm just saying. I mean, that the officer actually asked him that question.
What are they? The little alcohol that you put on your skin? You tell me that?
I don't know how it works, Judge. But I've never had a tattoo.
You're killing me. You're killing me, Smalls.
Your Honor, the law enforcement officer does state in the DIMS that there is a distinct odor of alcoholic beverage, emanating from the defendant's breath as he spoke.
Yeah,
That's
That it?
all we have before we initiated the standardized post-swearing test.
okay, that's not enough.
Might surprise people, but smelling alcohol isn't illegal. Being intoxicated while driving is. Texas law draws a hard line here, and Judge Fleer enforces it. No shortcuts, no assumptions, no stretching the stop.